Good afternoon, everybody. I'm looking forward to this, and we are just going to dive right in. The frustration that every new trustee struggles with is essentially this. What am I supposed to do as a trustee? How long is this going to take? And is everybody going to hate me at the end? The goal of this webinar is to show you how to be a confident trustee that can effectively manage a trust in a very timely manner, a trustee that is fair to the beneficiaries, and a trustee that honors the wishes of the persons who created the trust. When this happens, the trustee is a hero who ends up with a very happy family. In order to be a good trustee, a person needs to know what are a trustee's responsibilities. So in this webinar, I've broken down these responsibilities into 6 broad categories: authority, trust assets, beneficiaries, bills, taxes, and it's not as bad as you think, and then distributions. Before we turn to each category, I think it would be helpful to first learn some basic trust ideas so that we're all on the same page. The essence of a trust is that it is a fiduciary relationship in which a person, known as the grantor, gives a person, known as the trustee, the right to hold title to property for the benefit of a third person, known as the beneficiary. Let me say that again. A person, known as the grantor, gives a person, known as the trustee, the right to hold title to property for the benefit of a third person, known as the beneficiary. In other words, there are 3 primary roles or players in a trust: grantor, trustee, and beneficiary. One person can play all 3 roles, or one or more persons can be the grantor, one or more different persons can be the trustee, and one or more other different persons can be the beneficiaries. It is the trustee's primary responsibility. It is the trustee that has the primary responsibility in a trust. That is because the trustee is a fiduciary, which means that the trustee is legally bound to act in the best interests of the beneficiaries. I think it will be helpful to understand these trust ideas by using a real-life example. So I'd like you to meet our family. There's mom and dad and their 3 kids, brother, sister, and Jill. Mom and dad created a trust 10 years ago with carrier law as part of their estate planning. Mom and dad titled their assets in the name of their trust, and they named themselves the initial trustees and beneficiaries. This means that during their lifetimes, mom and dad played all 3 trust roles. They were the grantor, trustee, and beneficiary. 5 years ago, dad passed away, and a week ago, mom passed away. Their trust provides that upon the death of the last of them, then daughter Jill becomes trustee, and that Jill, brother, and sister are the trust beneficiaries. So the current situation is that both grantors have passed away. The role of trustee is now occupied by a new person, and that is daughter Jill. And the role of beneficiary is now occupied by 3 new persons: daughter Jill, brother, and sister. As parents sometimes do, mom and dad did not share a lot of details about their estate plan with the kids during their lifetimes. And so, as you can tell by the look on Jill's face, she has just found out that she is the new trustee. She is surprised because she does not know why mom and dad picked her, and she is not at all sure of what she is supposed to do at this point. However, as I stated earlier, this webinar is going to show Jill how to become the epitome of a good trustee that can effectively manage the trust, look after the beneficiary's best interest, and honor the wishes that mom and dad expressed in their trust. The first area that we're going to look at is how a trustee becomes authorized to act on behalf of a trust. Just being named as the trustee in a trust document does not give a trustee the authority to act. Rather, there are some documents a trustee must sign to get on board officially as trustee with the authority to act on behalf of the trust. To get on board officially, a trustee must sign what is called an acceptance of trust. To show the world that the trustee can act on behalf of the trust, a trustee must sign a certificate of trust. The certificate of trust is like a driver's license. It's a 2 to 4 page document that the trustee can take to banks, title companies, financial advisors, and others to demonstrate that the trustee has the authority to transact business on behalf of the trust. This way, the trustee does not have to haul around the entire trust document with him or her. In Jill's case, she retained her trusted legal advisor, which just happened to be Carrier Law, to prepare an acceptance of trust and a certificate of trust. Signing the acceptance brought Jill on board officially as trustee of Mom and Dad's trust, while the certificate of trust was a document that Jill could take with her to show that she was authorized to act on behalf of the trust. Jill signed these documents and walked out of Carrier Law with a sense of confidence, knowing that she was now officially trustee. Next, a trustee must determine what assets are titled in or subject to the trust. If the deceased grantor or grantors have not been particularly forthcoming about their assets, this may require the new trustee to put on his or her detective hat and review bank statements, real estate deeds, car or boat titles, stock certificates, bonds, certificates of deposit, investment statements, insurance policies, retirement plan statements, and on and on and on. In Jill's case, with the help of Carrier Law, Jill figured out that Mom and Dad's house, their checking account, and an investment account were owned by the trust. Jill learned that the trust was a beneficiary of Mom's life insurance policy, and that Mom and Dad had also assigned all of their personal possessions, such as their household goods, to the trust. This means that Jill was in charge of 5 assets: the house, checking account, investment account, life insurance policy, and Mom and Dad's remaining personal property. Jill also checked the title for Mom's car and determined that the car was titled in Mom's name only. This is very typical. This means that Mom's car was not a trust asset, and so Jill could not do anything with Mom's car in her role as trustee. However, as next of kin, there are Secretary of State forms that Jill and her brother and sister can fill out to transfer Mom's car. That is the subject of another webinar, and so we won't discuss the car any further in this webinar, except to note that the big takeaway is that there are ways for next of kin to transfer a deceased person's vehicle. Next, a trustee must determine who are the trust beneficiaries. This involves reading the entire trust to determine who is entitled to any portion of the trust assets. Trust beneficiaries can be anyone, i.e., a close family member, a distant relative, or even a friend or neighbor. Trust beneficiaries might also be an entity like a charity. There may be a specific gift to someone, for example, $10,000 cash to my friend Bill, or the investment account ending in 123 to my niece Mary. And there may be a gift to a group of people, for instance, $1,000 to each of my grandchildren and great-grandchildren. After any specific gifts, then there are the beneficiaries who get the remaining balance of trust assets. These beneficiaries are called the residuary beneficiaries. Once the trustee has determined who all of the beneficiaries are, a trustee must notify the beneficiaries that they are a trust beneficiary and that they are entitled to a copy of the terms of the trust that apply to them. In Jill's case, Mom and Dad's trust was simple and straightforward. There were no specific gifts, and Jill and her brother and sister were the residuary beneficiaries of a 1/3 share each. With Carrier Law's assistance, Jill mailed her brother and sister, as well as herself in her role as beneficiary, the required trust notifications. About a week later, sister asked for a copy of the terms of the trust that applied to her, which Carrier Law mailed to sister on Jill's behalf. Next, there are certain bills a trustee must pay and certain bills the trustee has the discretion whether or not to pay. The first type of bill relates to the trust assets. As part of a trustee's fiduciary duty to the beneficiaries, a trustee must maintain the trust assets. Thus, in the case of a house titled in a trust, the trustee must pay any mortgage because you don't want the bank foreclosing on the house, The trustee must pay the utilities because you don't want the pipes to freeze in the winter. The trustee must pay the house insurance because you want to be able to rebuild if the house burns down. And a trustee must pay the property taxes because you don't want the taxing entity to foreclose. All of these types of bills are legitimate trust expenses and are to be paid out of the trust's cash assets, such as the trust checking account. The trustee is not personally liable for these bills. The next type of bill are reimbursements to and compensation for the trustee. A trustee is entitled to be reimbursed for expenses paid on behalf of the trust, as often happens after a grantor dies, but before the trustee is officially on board. For example, the trustee may have paid a month's worth of the house expenses before the trustee was officially on board and had access to the trust checking account. In such a case, the trustee is entitled to be reimbursed for these expenses. A trustee may also be reimbursed for mileage driven on behalf of trust business. The trustee should keep a mileage log of the trustee's trips. A trustee can be paid a reasonable hourly rate for the time the trustee spends acting as trustee. What is a reasonable hourly rate can differ from region to region, but at Carrier Law, we advise trustees that a reasonable hourly rate in the Kent County area is somewhere in the neighborhood of $10 to $15 an hour for services like cleaning out a house, and $20 to $25 an hour for administrative services like meeting with attorneys, accountants, and other professionals and paying the trust bills. Please note that any amounts that a trustee is paid by the trust as compensation for services will have to be included as income on the trustee's personal income tax return the following year. The final type of bills are the decedent's final bills. These bills belong solely to the decedent, and a trustee is not personally liable for these bills. A deceased person actually has two types of creditors: unknown creditors and known creditors. An unknown creditor is a creditor who may be lurking out there somewhere that the trustee knows nothing about. A notice to creditors can be published for unknown creditors. The notice is published once in a local paper, and the notice period runs for 4 months. If at the end of the 4-month period, the unknown creditor has not submitted its claim, then the claim is forever barred. A known creditor is one that the trustee knows about because the trustee has received a bill from the creditor. In the case of known creditors, Carrier Law can assist a trustee in responding to known creditors on behalf of the trust. In Jill's case, Mom and Dad had always been very frugal. When she passed, Mom had her funeral bill and a credit card bill. The funeral bill was paid via a funeral contract Mom had purchased years ago. Carrier Law responded to the credit card company on Jill's behalf. Carrier Law also published a notice to creditors, and no unknown creditors came out of the woodwork. Once Jill gained access to the trust bank account, she reimbursed herself for some expenses related to the house that she had paid. She decided to pay herself mileage, but decided to forego paying herself an hourly rate because she did not want to deal with having to include this compensation on her own personal income tax return the following year. Next, we are going to talk about taxes, but this is not going to be an in-depth tax review. Rather, the big takeaway is that a trustee will need to work with a tax professional to determine two things. First, if the deceased person needs to file a final income tax return, and second, if the trust will need to file a trust income tax return. We're not talking about estate tax, which is a tax on the entire value of all a person's assets, including trust assets. There is no estate tax due unless the assets are worth between $10 and $11 million in 2021. Rather, we're talking about a trust income tax return. A trust needs to file an income tax return if the trust assets make above a certain amount of income in a trust tax year. For example, interest on a checking account or gains on an investment account, or if any of the trust assets are required to be taxed when distributed to the beneficiaries, for example, distributions from an IRA. In Jill's case, she retained an accounting firm who assisted her in preparing Mom's final tax return. The accounting firm also determined that the trust would have to file an income tax return because Mom's checking and investment accounts made enough interest and gains that required a trust tax return that it needed to be filed. Again, just let me say that the big takeaway concerning taxes is that a trustee needs to consult with a tax professional at some point during the trust administration process. Next, we're going to look at how a trustee makes trust distributions to the beneficiaries. In order to prepare to make the trust distributions, the trustee typically liquidates the trust assets. This can involve selling the house, closing bank accounts, cashing out claims like life insurance, IRAs, investments, or bonds, and selling stock or other assets of the trust. This process can take very little time or can take a year or more depending on the type of assets. For instance, if the trust assets consist of only cash accounts like bank accounts, then trust administration can take very little time to complete. If the trust assets include a house that needs to be cleaned out and sold, then trust administration can take up to a year or more to complete. There is no amount of time that is right or wrong for trust administration. However, the typical amount of time is probably 4 to 6 months. This is a very reasonable amount of time when you consider all of the things that we've talked about up to this point that a trustee has to do. This time period actually goes much faster than you think it would, and in addition, the family avoids the hassles of having to go through probate by having everything in the trust. Once the trust assets have been liquidated, the trustee should prepare an accounting for the beneficiaries. This accounting should show at the very least the total amount of trust assets, the expenses that were paid by the trust, and the balance remaining. From this, the trustee will be able to determine each beneficiary's share. Before the trustee makes final distributions to the beneficiaries, the trustee should ask the beneficiaries to sign a release in which each beneficiary agrees to the amount of their distribution and agrees to hold the trustee harmless in the administration of the trust. The release is important because a trustee may encounter family problems during trust administration. Someone has died, people are grieving, and emotions can run high, and family members can do unexpected things. For example, you may have a family member who thought it was okay to go in the deceased person's house and help themselves to whatever they wanted. You may have a family member who thinks they are going to tell the trustee the assets that are going to be distributed or what assets this family member wants. Or you may have a blended family where tensions run high between the children and stepchildren of the deceased person. Or you may have family members who have been estranged from each other, sometimes for years. The trustee is the one in charge and has the authority to determine what the trust says about the particular issue in dispute and the discretion to resolve it. A lot of situations end up being minor annoyances and are ultimately resolved. However, know that sometimes beneficiary disputes can escalate even into litigation. Carrier law understands that this is an emotional time for families, and carrier law can assist the trustee in diffusing situations before they escalate. Oftentimes, it is simply counseling the trustee on how to approach a situation. For example, counseling the trustee to firmly and politely tell the know-it-all beneficiary that the trust assets will be distributed according to what the trust says. Other times, carrier law can play the bad cop and contact the beneficiary who took mom's wedding ring and inform the beneficiary that it must be returned to the trustee before the final distributions will be made. In Jill's case, she sold the house using a realtor and title company and liquidated mom's investment account and life insurance and put all the proceeds into the trust bank account. From there, she did the trust accounting and calculated her and her siblings' share of the trust assets. She did have a small problem with sister, who started demanding her distribution within a week of mom's passing and who wanted more than her share of mom's personal property. However, Jill handled this situation by patiently talking to sister and informing sister that no distributions would be made until trust administration was completed and that all distributions would be equal. At the end, the beneficiaries, brother, sister, and even Jill, all signed their releases for their distribution. The end result was a happy family, as you can see in this picture. Jill was happy because with carrier law's help, she knew what to do as trustee. The process did not take nearly as long as she had feared, and she honored her mom and dad's wishes as expressed in the trust. To her appreciative siblings, Jill was a hero who took care of everything and was fair to everyone. And thank you very much. That's what I have prepared for today, but I am more than happy now to take your questions.
Thank you, Lee, for all that wonderful information. I'm going to put your video back on
Okay.
so that you can answer questions. Can you put your video? Can you see how you can put your video on?
It says you have stopped it.
Oh, let me see. Sorry about that. Just a second, please. Well, we do have some really great questions.
Good.
So I'm going to stop my video, and maybe that's how I can stop your video, but we'll both be here. The first question is, acceptance of trust documents is signed by a trustee only after death of the trust grantor. Is this correct?
No, that's not necessarily correct. Sometimes, in the case of a husband and wife, let's say one of them has passed away and the remaining parent wants to bring one of their children on board. In that case, they can do that, and the child that's going to come on board as trustee will sign an acceptance then. So it's just not after both grantors have passed. Just anytime a trustee is going to come on board and they have not previously, if they were not named an initial trustee in the trust, anytime after that, if a new trustee is coming on board, they will have to sign the acceptance.
Okay. Oh, good. So the video came on. Wonderful.
Yes. Yes.
Excellent. Okay, next question. What if you have no trustee or the named trustee refuses to accept the responsibility? Are there third-party solutions?
Well, the first thing I would look at would be to look at the trust and see if there's a trustee named after the first trustee. I think at carrier law, we always try to name at least 2 or 3 trustees. If there is nobody else named and this is the only person, then the option might be to have to go to court and have the local judge name a trustee.
So typically on a trust, how many people are named?
I think it depends on the client that we're working with. Sometimes they just want to name one and that's it. But I think in the typical case, we usually have 2 or 3 individuals, and then we always backstop that with an entity like West Michigan Community Bank, so that there's always at least somebody that can take over if needed. Okay. But like I said, if it ends up that there's nobody, because sometimes the entity at the end, which can be a bank, something like that, if let's say the estate is not big enough, or there's no assets in it, or not enough to make it worth their while to manage, and they decline, then the final option is to go to court and have the probate court judge appoint somebody.
When is the acceptance of trust signed?
Well, I guess the best way would be just to give you some examples. Like in the case we did here, mom and dad had been the grantors and the trustees. Mom was healthy enough, fortunately, throughout her life. She, once dad died, she continued to act as trustee and manage it. She then passed away. And so at that point, before Jill could come on board, she had to sign the acceptance. If mom had wanted to bring Jill on board before that, then Jill would have signed the acceptance at that time while mom was still alive. So it just kind of depends on when the trustee needs to come on board.
Where did they get claim forms?
Typically the companies. So let's say there's an investment account, there's an IRA, there's an insurance policy. Here at Carrier Law, what we will do is the trustee usually has at least a statement of this asset. They may have found it in mom or dad's belongings. Also, here at Carrier Law, when mom and dad would have gone through and done their initial estate plan, and then Carrier Law's funding department would assist them with putting their assets in the trust. We keep a list of that. So my department in trust administration, when the last grantor passes and the kids come in for trust administration, we're usually fortunate enough to have a list of what the initial assets were when mom and dad did their trust. Now, sometimes things get sold, houses get sold, investment accounts get closed out. But one way or the other, we try to compile a list of what the assets are. And then from there, we'll call the IRA holder, we'll call the insurance company, and we will just ask them to send a claim form to the beneficiary on file. Or if the asset is owned by the trust, we can ask them to send the claim form to the trustee. And then we will always help the trustee fill out those forms.
Okay, great. So you're a great resource all the way through the process.
Yes, we try to be.
Another question, should assets be distributed to beneficiaries before the IRS releases the trustee of personal liability?
Well, the trustee has no personal liability, no personal tax liability. But we always recommend that the trustee check with a tax professional to see what, if any, tax liability the trust is going to have. And so what often happens is we do the distributions this year, but any tax documents, if there's going to be any coming from any of the companies that held these assets, the trustee won't get them till next year to include on next year's trust tax return. So often we have the trustee check with the tax preparer this year to find out at least how much it would be to prepare the taxes for next year. They may even pay that ahead of time, that preparation fee. And we'll also see if they can get some sort of estimate about what the taxes might be. And then they'll hold that back in the trust account until next year. So in some cases, we will distribute the bulk of the assets this year and then hold some back and then do a final distribution next year once the taxes have been paid and taken care of.
He said this is the purpose of Form 5495 and the process takes 9 months.
I'm sorry.
Must be a tax form.
Yeah, I don't know what that is.
Yeah.
Sorry. I know that the trust tax return form is at the 1041, but again, we always tell people we're not tax professionals, which is why we always tell people they need to contact a tax professional to help them. We know just enough probably to be dangerous.
Should the release form be a legal document prepared by an attorney, or does it have to be?
Well, we will prepare agreements and releases. I would say even if you just prepare a 1 or 2 line source release and the beneficiary signs it, it's certainly something that you could take if an issue arises after that fact. Let's say that they sign it and then a month later they come back and say, hey, I didn't get the right amount. I've got a complaint. And again, you always have to look at this. The down the road view is this, where does this end up? It ends up in court. So if they have signed something, that's some evidence. Is it going to be able to be used conclusively against them? That's just nothing we know until you would get before a judge and let the judge make that determination. But I think the basic idea of the release is it does, make the beneficiaries take pause. Hopefully they realize if they do want to raise any questions, this is the time to do it.
Great answer. Thank you, Lee. Is the grantor liable for bills outside of the trust, like credit card or vehicle purchase?
Now the grantor is the one that creates the trust. And in our situation, that was mom and dad. So if they're still living and the bill is their bill, yes, they are absolutely liable. If they've passed away, then what we do is we say that the bill was their responsibility only, and so it's not the trustee's responsibility after they pass away. I hope that answers your question.
Okay. Do you need to declare all monies in an amenities trust when applying for Medicaid or SSI?
Yeah, that's going to be, sorry, that's going to be beyond the scope of this. We have a Medicaid department that handles all those types of things. So maybe you can keep an eye out, and when our Medicaid department does do a webinar, hang on to that question and ask them during that time.
Okay. I'm not sure what an amenities trust is.
It's probably similar to a supplemental needs trust.
Okay.
And again, that's just, go ahead, Chris, I'm sorry.
Yeah, I'm sorry. Another question, another great question. What if the trust does not appear to be consistent with the previously written will? Will that end up in probate court?
It could, absolutely. But again, the will controls what's in a person's probate estate, and the trust controls what's in the trust. So I always tell my paralegals there are three basic ways, and you know, it's never as simple as the simple answer, but to think of it, here's the three big ways to think about how property passes when somebody dies. If it's titled in the trust, it's going to go according to their trust. Property can also pass by beneficiary designation, and if it doesn't pass by either of those ways, then it's still in the person's name only, and it's in their probate estate. For instance, if they died, they never did anything with their house, and the house is still in their name. It's in their probate estate. So with regard to assets in a person's probate estate, the will controls, and with regard to assets in the trust controls.
So if people created a trust but didn't fund the trust, then those trusts would be controlled by the will and have to go through probate court?
Yes.
Okay.
Yes. Yep. If it's above the probate threshold, which is typically in 2021, $24,000. If the amount of assets in a person's probate estate, that is in their name only, is more than 24,000, then the person's estate has to go to the probate court.
Okay. What happens when there is an ongoing business owned by the trust? Can the business continue?
I'm going to be honest with you. I've never done one trust administration since I've been here where we actually had a business owned in a trust. But that's a very good question. I guess you'd have to look. Generally, I'm just going to say, I think you'd have to look at the controlling documents that control the business, and that is going to control what can happen. For instance, I guess I take that back. We do currently have a matter where we have an LLC that looks like it's a one-member LLC, and that member is a trust. So, but an LLC has an operating agreement, and I look through the operating agreement, and it provides for what happens if a member dies or if the members decide to stop doing the business. So I would say in the case of your question, you'd want to look at the controlling documents and see what they say, and they should guide you.
And would they be able to come in and sit down and have you and or David review those documents to make an assessment ahead of time?
Absolutely. Okay. Yep. Either me or probably most likely Bill Bareza. He does a lot. He does a lot with businesses.
Okay, great. What if you have been named as trustee, but you did not sign acceptance, but did agree verbally?
Agree with who, I guess would be my question. It's just always better to have it in writing. And if that's the situation you're in and you're acting as trustee, I would suggest that you probably should reduce it to writing. just so that it's official, and that you may, this is an old, okay, so this is an old law school concept that I'm dredging up out of my memory banks. You may have to, or may want to then go back and ratify things that you've previously done while acting as trustee without having signed an acceptance. Again, just so that everything's, dotted and crossed and tied up, so you don't expose yourself to any liability. That is what I would do.
This is a good one. I think this is a question I've heard before. So, is it better to have vehicles registered in the name of a trust or keep it in the name of the owner?
We always tell people, keep it in the name of the owner because
Yeah.
of liability, especially with the change in the insurance laws. Keep it in the name, the personal name of the owner, and not in the name of the trust.
Great. Is it possible? We have a lot of great questions, really.
Yes,
I love
thank you.
this. Is it possible for a trustee to start taking care of business when the only surviving grantor is mentally or physically unable to manage the trust? That's a great question.
Yeah, absolutely. That's the whole purpose. The assumption is that you're already on board as trustee. If not, hopefully there's some sort of disability panel in the trust or some other mechanism in the trust by which, if the remaining grantor becomes incapacitated, the next in line trustee can come on board. So yes, absolutely, you want that.
So is that typical where you would get two doctors to sign off or some form?
Yeah. So, yeah, something like that. Sometimes, depending on the trust, I've seen where it might be a majority of the kids, vote and decide that mom can no longer, handle the trust assets. It's just whatever the mechanism is in the trust, which would be what the grantor decided they wanted when they originally set the trust up. What mechanism they decided would work once they become incapacitated to remove them and bring somebody else on board.
Yeah. How does one handle a beneficiary refusing to sign an agreement after the last grantor passes?
I'm going to say that I'm going to just rephrase that a little bit. I'm assuming that the grantor has passed, the trustee has gone through trust administration, ready to wrap things up, and you've got one beneficiary that doesn't want to sign. There's a couple different ways you can go, and it's going to be within the trustee's discretion. And it's going to depend on how big of a problem this potential beneficiary is. If you decide or want to take, if the trustee decides or wants to take the risk that they're not going to get sued or the beneficiary isn't going to come back later, write them their beneficiary check. The better way to go would be to go to court and ask the judge to approve the distribution. Once the judge does that, then the beneficiary would not be able to come back on you. So the best course is if you've got somebody that refuses and does not want to sign that release. We at Carrier Law just think that release is so important because people can just do very unexpected things, and somebody that you thought you knew that would never come back after you, they do. So rather than take the risk that a month, a year, 2 years down the road, they hire an attorney and file a petition to reopen the trust, just go to court and let the judge sign off on it. Then you've got that court order, and that should take care of it.
And then you don't have the liability or any worries.
Exactly.
Got that peace of mind.
Exactly, because when you go to court, then the trustee is, the beneficiary then is forced to say what their problem is. And if it's just that they're being difficult and they don't have anything really to go after you about, then the judge should go your way.
Yeah. And would the fees for that come from the trust itself?
I'm going to say I believe so in a case like that. Mm-hmm. I think we recently just we're kind of looking at that issue as to when a trust and trust can pay for litigation. But I think in a case like that, where we've just got a stubborn trustee, I believe that the trust would and could pay for the fees to go to court and get that taken care of.
You mean a stubborn beneficiary, right?
Yeah, yes, if I misspoke, yes, a stubborn beneficiary, yes.
So how does the court determine who the trustee will be when there is no one or a bank willing to take on the responsibility?
Well, what I can give you is just a couple of examples where we've done that. And in that case, we have worked with some professionals in related fields like fields of accounting. And so we have asked one of these professionals to take on, if they were interested in being the trustee, and if they said yes, and we were acting on behalf of the trust, then we went to the court and asked that this person be nominated. So if there is nobody else, but you're a beneficiary of the trust and there is somebody that you would like appointed, that is how you would do it.
Okay. Next, grandkids are able to collect their share when they're 25 years old. Where should their portion be held?
I'm assuming that is what the trust that you're currently involved in says. Typically, a share will be held in a bank account, and typically the trust is going to probably, I guess, to back up, my only experience really is with the trust here at Carrier Law. And so typically the primary trustee, who we also called the general trustee, if the grandkid doesn't have any access to the money until they're 25, typically though, the general trustee can distribute maybe just income to them, or maybe able to distribute income and principal. So typically that asset would probably be held in a bank account, and the trustee could distribute to that child and grandchild as they see fit until the child turns 25, and then can take over the account or cash it out or do what they want with it.
Trust grantor can set up trust in such a way that all assets remain in the trust after grantor death, and only income from assets be distributed to the beneficiaries. Is this true? Maybe they're talking about the separate share trusts that are created after the people pass.
Yeah, I'm going to be honest with you. That is something that I would welcome you to contact me at a later date. I don't know if legally if you could do that, set up a trust where only ever income and not principal could be distributed to the beneficiaries. It very well could be. I don't know. That's not, we've never done it. I have never done a trust like that. Typically, the grantors set up the trust to be able to manage their assets during their lifetime, and that with the goal that they're able to pass something on to their children and grandchildren after they pass, which
Right.
typically involves liquidating the assets and distributing not only the interest or income, but also the principal.
I think what they're talking about, though, and I could be wrong, but again, maybe that's a separate conversation.
Yeah.
So,
Yeah.
Is the acceptance of trust document included in the paperwork for the trust?
No. No, it's not. That's something that we've just drafted. That when somebody retains us for trust administration, we have the trustee sign. But when the grantors create the trust and they sign the trust document, they're signing as grantors and trustees. So they don't sign an acceptance at that time. So there's no acceptance included in their documents, at least as how we do it here at Carrier Law.
Okay. What are a couple of the most frequent mistakes that trustees make?
I would say the number one would be going ahead and doing distributions before. We've had Carrier Law has had the opportunity to assist the trustee in doing the accounting and sending out the agreements and releases. So that happened with me early on when I took over as supervisor, where we'd be talking to them, you know, we've liquidated the assets, the house got sold. And so I would call them and say, okay, so we're going to need bank statements so we can do the accounting. And it's like, well, I already mailed everybody their check. So now I try to make that a consistent theme throughout trust administration, starting with the second meeting where we have the trustee come back in and sign documents like the acceptance. I'll go through the entire trust admin process with them, and I'll tell them when they get to the end, after everything's been liquidated, I just want you to think of a big red stop sign. You're not going to do anything, send out any checks until the accounting is done and we've done the agreements and releases. And I continue to hammer that now so that we don't have that happen. That's probably the most common. I'm trying to think of other things. I think not so much a mistake as just not understanding how trusts work. And so just being confused by what needs to be done. And so that's why during my presentation today, I talked about the grantor, the trustee, and the beneficiary, just to kind of give you an idea of the players that are involved in this. Because that's probably the second most common thing, is just a lack of understanding as to what all this is about.
Mm-hmm. So you really need to have kind of like a playlist on and steps to go by in order to do it accurately and legally, and make sure that at some future date, something doesn't come back at for whatever reason.
Exactly. Yes.
Okay. Yeah. The next question is, do we deal with firearms trusts? And I think those are the gun trusts that Jim Henke works with.
Yes, that's nothing I do, but I know that we do have a gun trust.
Yeah.
So if that's something you want to talk to somebody about, I would just encourage you to call the main number there that's shown on the screen and just say that you'd like to talk to an attorney about that, about a gun trust.
Yeah. If one of the beneficiaries has passed, does his or her share of the assets go to his or her family, or are the assets divided equally among the remaining beneficiaries, and the deceased beneficiary's family gets nothing?
It depends on when the beneficiary passed and what the trust says.
Yeah.
So yeah, you just have to look at the trust document. Our trust will typically say if the beneficiary has died, we'll typically provide where those assets will go. So you just really need to check the trust document.
Okay. And that's something that they can come in and review with you as well?
Absolutely. Yes.
Okay, great. What court would they go to?
You would go, if you have anything with trust issues that you need to go to court, you're going to go to probate court.
Okay.
And there's certain documents. A lot of the documents are already preset. So let's say you wanted to go to court because you've got a stubborn beneficiary that will not sign the agreement and release, and you want to go ahead and get the judge to sign off on it. You would, I believe, file a petition for complete estate settlement. And again, that is a form that's already done by the courts. If you're looking for more unique or specific relief or assistance from the court, then you might retain an attorney to custom draft a petition for you that would ask for the relief you're asking for. But it's the probate court for trust related things that you're going to go to.
Yeah. Okay, thank you. This is a great question. Do all the beneficiaries know what each other are receiving when there are families and friends listed?
Not necessarily. Again, that's going to be up to the trustee. We have some trustees that it's fine if everybody knows everything. They want to be transparent with everybody. We have some trustees that are very private or believe that their parents were very private and did not want everybody to know everybody else's business. So we always allow the trustee to make that decision. When we send out, if we do have a beneficiary that does request the terms of the trust, as it says, they only get the terms that apply to themselves.
Oh,
So let's say in the residuary clause of the trust, let's say you've got 4 kids, 3 of them get 10% and 1 gets 70%. And one of the 10 percenters wants to see the terms of the trust. We would black out everybody's name, everybody else's name and their trust share, and we would just send them that beneficiary that particular provision that they're getting 10%, and that's it.
so it could be a thing where even though there are 4 kids, there could be 10 different people getting 10%. They would have
exactly,
no idea.
exactly.
Okay.
Yes.
Yeah. That's a good one. Do you advise on estate liquidation?
Well, that's typically done through probate. If I'm understanding your question correctly, when you say estate, to mean that to me is that middle way of how a person's property passes. If it doesn't go by trust, or if it doesn't go by beneficiary designation or transferred on death designation, it's in their estate. And so that's handled by our probate department.
I'm also wondering if that that could also mean if someone, the house has got to go and it's a house that's been in the family for many years and everything has got to be gone through to liquidate the estate. Do we have companies that we would refer to people who could
Like,
maybe help with that?
like go in and just buy the entire contents of the house?
Or just advise them on this has no value, please donate. This is,
Oh,
this is a cherished, ruby egg.
yeah, there's a lot. We don't have anybody specific that we can recommend on that, because there's just a lot of those people out there. So
Okay.
typically it's not been a problem if one of our trustees wanted the assistance of a company like that. I don't think they've ever encountered a problem in finding a company like that.
Yeah. Yeah. So if a beneficiary is handicapped and unable to handle large value assets, then the trust should hold the assets under its management.
Well, again, we've got to go back to what the trust says.
Okay.
And so hopefully, in the perfect situation, the grantor of the trust that made this handicapped person a beneficiary was aware of the handicap. And so hopefully they made arrangements in the trust for the handicapped person's assets to be held after the grantor passes. One of the ways we do that is with a supplemental needs trust, where another party is appointed trustee for this beneficiary and then manages the assets on behalf of the handicapped individual. But
Could
again,
that be like another sibling or something?
Yeah, it all depends on what the trust is going to say. The trust should say who the trustee for this individual's supplemental needs trust will be. They used to be called the amenities trust. I know somebody used that term earlier.
Oh, yeah.
Currently we use the supplemental needs trust. So again, the trust document controls.
Great. Oh, this next question is good. It gets into the kids. House is in a trust. One beneficiary wants to keep the house but can't afford a new mortgage. Others want to cash out and obtain their share of house value. How may this be resolved?
Well, basically, if the one that wants to keep the house can't come up, the trustee ultimately will make the decision.
Okay.
So the trustee has the authority and discretion. And if the one that wants to keep the house is not the trustee and they can't come up with the financing to pay off the other beneficiaries, more likely than not, the trustee is going to sell the house. It's just as simple as that. There's just nothing else you can do.
Okay. Is there sometimes something in the trust that says it can someone has the right of first refusal or something like that, and then if they
Absolutely.
can't, then,
Yes.
so the grantors could put in provisions to, for lack of a better word, mitigate any family arguments in this situation.
Yes, like if the one that wanted to stay in the house, they could give that beneficiary the right of first refusal, dependent upon, getting adequate financing. It's however the grantor wants to structure it. But ultimately in disputes like this, it is the trustees, within the trustee's discretion to resolve those disputes as long as they're done according to the trust.
Okay. So ultimately, the trustee has their responsibility, and even though if there's 3 other kids in the family, or 8 or 10 or 11, it's still the trustee who has to make the decision.
Yes.
On, okay.
Yes.
Because
Now for
they're the
everybody,
one who was trusted by the parents.
yes. And that typically the trustee has to step in and make a decision like that if everybody else can't agree. If
Okay.
everybody can agree, we sometimes do agreements that kind of change the trust distribution slightly. But again, we only do those if everybody's in agreement,
Okay.
all the beneficiaries and the trustee. Other than that, the trust provisions control, and the trustee is the one in charge and makes the decision.
So what's the first thing someone should do after their loved one passes?
We have got a whole host of literature on that if you want, there's actually in our trust packet, which I don't have with me or access to right now, we have a list of things. There's other lists of things.
When should they contact the attorney?
We always tell people, be with your family first. You don't have to do anything the next day. You don't even have to do anything the next week. When you're comfortable, after you've had time to be with your family and at least, done some grieving, just reach out to us when you're comfortable doing that. If you want it to be the next day, it could be the next day. But it doesn't have to be. There's typically nothing so pressing that it can't wait for a little bit of time until the emotions settle down, and then you can contact us. But it's whatever your comfort level is.
If I'm the trustee and the only beneficiary, do I just distribute the assets to myself?
Pretty much in a situation like that, yes, because who's going to complain? Right.
But do you still have to go through the trust administration process?
Well, sometimes in a case like that, you don't necessarily have to go through the entire process, but you still want to, if you were not on board as trustee while the grantor was still alive, you'd still want to accept. You still may need to get a tax ID number for the trust now that the grantor has passed away, and we can help you with that. You still may need help liquidating the assets. If there's a house to be sold, you may need help with that. Probably the only thing that that maybe doesn't need to be done because there's not other people involved would be the accounting. And we would even still do accounting for you, because we just do that. We just do the trust accounting for everybody, whether it's just one beneficiary trustee or not. But then at the end, obviously you wouldn't need to do an agreement and release for the other beneficiaries because you're the only beneficiary. But even though you are the only one, there's still some things we can help you with. And we do a lot of trust administrations for sole trustee beneficiaries, just because they want the peace of mind knowing that things are getting wrapped up for mom and dad correctly.
Yeah. What is the cost, Lee? And can the cost be paid from the trust?
The cost can be paid by the trust. That is a legitimate trust expense. However, the cost depends on a lot of factors, and that's just nothing I can give you today. We're going to look at the number of beneficiaries, the type of assets, the number of assets, but we do a first meeting with you called a first trust meeting at which we would look at all those things, and then we can, after we know that information, we then quote you a price.
Okay. Can the trust assets be paid out incrementally, such as so much per year to beneficiary?
Yeah, yes. Typically what happens is, or I guess not typically, but what we've done in the past is, as I alluded to earlier, if you think there's going to be a tax return with some tax implications due next year, but everything's liquidated, we might do one big distribution this year and then just hold back enough to pay for those estimated taxes. And if there's anything left over next year, do one set of final distributions next year. We call that first big distribution, that'd be an interim distribution. For some families, what we do is we've done 2 or 3 interim distributions as an asset got liquidated. For instance, let's say a big investment account was cashed out. It was titled in the trust. It was easy to cash out right away. So that was cashed out, and we did an interim distribution of that. Then let's say something else was cashed out in 2 or 3 months, and we did an interim distribution then. And then maybe several months after that, the house finally got sold, and so we did an interim distribution after that. Again, here at Carrier Law, each time we do that, we like to do an accounting, and we also like to have the beneficiaries sign agreements and releases. So it's kind of a cumulative thing. I can't say that we've ever had a trustee that, let's say everything is liquidated and then they wanted to just dole out $50,000 a year for the next 10 years to the beneficiaries. That's not a typical scenario. But we do have a situation where a land contract will be paying out. The trustee is getting land contract payments once a month. But rather than dole out those payments as they come in monthly, we've agreed that he's going to collect the payments for a year and then once a year do a distribution of those previous 12 months worth of land contract payments. And those are supposed to come in for another 3 or 4 years. And at the end, when the last payment will be a balloon payment, and we'll do final distributions then. So again, the trust is going to control that. You know, I just think if the trustee, it was a situation where the trustee just wanted to hold a bunch of money back and dole it out, you'd probably have some beneficiaries kicking up a fuss.
Great. I just launched a poll just on the, if everyone can just take a moment and fill that out, I would really appreciate it. Another question. If you have things in the protection trust, does the trust continue intact with just the owners of it changing?
Read that again, Chris.
So I think what they're talking about is after you have the protection trust, and after the grantors pass away, that's where I believe in the trust they can create their separate share trusts. And so so what they're saying is, if you have a protection trust, does the trust continue intact with just the owners of it changing?
Yes. What happens when you have a protection trust and the grantors have passed? So the trustee is, what the trustee owns is legal title to the assets. The beneficiaries have equitable title. So what happens, the grantors pass and we bring a new trustee on board. And so the new trustee takes legal title to those assets and then manages them for the beneficiary's benefit until distributions are made. I hope I answered your question.
Well, I think that is our final question of the day. Again, thank you so much, Lee, for sharing your expertise here today. We had a lot of incredible questions.
Yes, thank you.
Yeah, the presentation has been recorded. I just got to convert it, and it will be up on our website early next week at the latest. And that would be under the free workshops tab on the website, and then educational series. At the bottom of that, web page will not only be this presentation, but the presentations we've already had on probate and trust administration. And then up next month is a presentation on funding. So again, I thank you all for coming today. If you can take a moment to take the poll, be very much appreciated. Thank you so much. And
All
have a
right.
great
Thank you very
afternoon.
much. Yes.